Oil, natural gas, gold, hey, it exists below the ground. And if you don't own the ground above it, how do you get to it? Well, that takes us to this week's case. Involves a real case involving real people, arose in West Virginia. And there was a family, the Whiteman family. The Whiteman family owned approximately 110 acres of farmland. They raised sheep, they raised hay. Well, they did not own the mineral rights underneath the property. That had been severed by deed, and that mineral right underneath the property was owned by another company. And the company showed up one day and said, we're going to drill for natural gas, which they did. So they came onto the property, drilled for the natural gas, and when they drilled for the natural gas, well, they used this process in which they injected material into the well to try and extract the natural gas. In the business it was called mud, and when they put this material into the well, it came up along with the natural gas and along with various bits of debris that was a result of the drilling process. And well, all of this stuff, this mud and this debris and everything, they put it in large pits that were in the area where they were drilling on the farm. After it was all over and done with, they wrapped up their operations. They removed the plastic lining from the pits. They then brought in more soil and dirt. They mixed it all together with the debris that they had produced and then compacted it, so basically things look pretty much like they did, except that it was now kind of beat up and raw land, as when they started. Okay, things move on. The Whitemans now want to use this 10 acres that had been used for the drilling purpose, and they find out they can't. They can't. Nothing's going to grow there. They can't do anything with it. It doesn't grow any crops, doesn't grow any hay. They're concerned with feeding their sheep off of anything that would grow there. And so they say, you've damaged 10 acres of our farm. You've damaged 10 acres of our farm. We didn't buy into that deal. We didn't buy into that deal at all. So they sued the company. They sued the natural gas drilling company, and they said, you have trespassed upon our property. And the way trespass is defined in West Virginia is that you unlawfully enter the property of another and you damage it. They said they came on here, they damaged our property, we're suing for trespass. Well, on their side, the natural gas drilling company said, no, we did nothing wrong. We did nothing wrong. We did nothing wrong. We had a right to come onto this property because we owned the mineral rights underneath it. And two, the way in which we disposed of all the refuge and the debris from our drilling process, that was allowed by West Virginia law. Therefore, we owe you nothing. Well, the case went to a U.S. federal district court. And the U.S. federal district court essentially sided with the natural gas drilling company. So, the Whiteman family appealed, went up to the 4th District Court of Appeals for 4th Circuit Court of Appeals for the United States. And it got up there and the court looked at it, they heard the various arguments. And they carefully considered it. And they said, you know what? In this instance, essentially, there were two deeds for all intents and purposes, because the interest in the property had been severed, had been broken into two. There was interest in the property that was the ground property, and then there was interest in all mineral rights which existed underneath the property. Well, under that scenario, the party who owns the mineral rights underneath the property have a right to come onto the property and extract the material. So there was no trespass in the sense that they had a right to be there. Two, they had a right to remove the mineral rights. That's what they owned. And then three, and this is where we have some problems, how did they dispose of all that debris? Well, they did it pursuant to the law in the state of West Virginia. So we find in this instance that the guys that were drilling for the natural gas, did nothing wrong. They did everything that was allowed under the law, and therefore there is no cause of action for trespass. And that was the end of the case. So what do we learn from this case? We learn a couple of things. One, as you may have already been aware, when it comes to real property, you can sever property interests. You can have interests that extend to the surface property and interests which extend to the mineral underneath the property. Well, in many parts of the country, in the eastern part of the United States, generally property is not severed, but in the western part of the country, it very often is. And even today in the western part of the country, those parts of the country that are owned by the federal government, and believe it or not, some of the western states still have large tracts of land that are owned by the federal government. If you were to acquire a tract of land from the federal government, what you would find today is that there is in the deed a reservation of the mineral rights. So what could happen? You can buy that property, maybe you've got a ranch suddenly out in the middle of Nevada, and guess what? Federal government jumps up and auctions off the mineral rights. Turns out that there is some valuable material underneath that. Well, guess what? The guys who purchased those mineral rights can now come onto the property and can look for those mineral rights, can extract those mineral rights. And now the big question is, what about the way in which they deal with the debris and all the kind of stuff, the garbage that's left behind from their extraction of the mineral rights? Well, that's something that people can do something with that wasn't done in that case, and that is they can enter into contracts that specifically specify how that material will be removed and what, more importantly, will happen with the debris. None of that had been specified in this case. The Whiteman family had not entered into any agreement with the guys that were removing the natural gas. So what do we learn from this? What we learn from this is you may own the surface property, but you may not own all the property. You may not own the mineral rights underneath the property. And if somebody else owns those, however, you can enter into agreements with them as to how those minerals will be taken out of the soil, because it impacts your property rights on the surface. Okay, hey, we bring you this case as we bring you cases every week, so you understand how the law works. I'm David Allen.